Hello everyone, I'm Jed Rubenfeld and this is Straight Down the Middle. I'm going to be talking to you today about the indictment of James Comey. As you know, just a couple of days ago, in a rush proceeding down in Virginia, a federal grand jury issued an indictment against former FBI Director James Comey. Now, a lot of people are very upset about that. The New York Times calls it a break glass moment, an unprecedented threat to democracy. Well, is it the revenge prosecution that the Times calls it? Is it unconstitutional? Or is Comey actually guilty of something? Did he commit a crime? I'm going to be talking to you about all those things today. And, these are tough issues and people disagree a lot and pretty passionately about them. But I'm going to give you my opinion and I'm going to try to walk you through the indictment and the legal analysis of the indictment. So let's jump into it. What exactly are the charges against Comey? The indictment is just 1.5 pages long. Very unusual for a federal indictment in such an important case. Just 1.5 pages, and it charges Comey with 2 crimes. The first crime is making a false statement. The allegation is that in his testimony before the Senate Judiciary Committee back in September 2020, first charge is that Comey lied when he testified that he had not authorized someone else to be an anonymous source for news. Now, what the heck does that mean? Well, the allegation is that Comey authorized somebody, told somebody to anonymously leak information to a newspaper, and then he claimed he didn't in this testimony to the Senate Judiciary Committee, and that kind of testimony, that's under oath. And if you lie in that testimony, you're committing a crime under federal law. And so that's the first charge. Second charge is obstruction. What's that? The indictment says that Comey tried to impede or improperly influence the Senate Judiciary Committee's investigation by making false or misleading statements. What false or misleading statements? The indictment doesn't say. That's it. I have now just summarized to you the entirety of the indictment. That's what it says. So people are speculating about it. People don't know what exact false statements, what exact conduct the indictment is referring to. As to charge 1, people are speculating about. They have different theories about who the someone else is that Comey allegedly authorized to leak anonymously to a newspaper or to the media. One theory, and this is the one that was first reported. In fact, all the initial reports assumed that this was right. One theory is that the someone else was FBI Deputy Director Andrew McCabe, who did, in fact, anonymously leak information, arguably confidential information, to the Wall Street Journal back in 2016. And so a lot of people thought that the claim was that Comey had authorized him to do that and then lied about it, pretended he hadn't. Now, another theory, which actually I think is stronger. Another theory is that no, the someone else is not Andrew McCabe. The someone else is a law professor, a Columbia law professor. This Columbia law professor is a friend of Comey's and was actually had special employment status at the FBI at the time. The Columbia law professor, his name's Daniel Richman, and it turns out that in fact, in 2017, he leaked anonymously certain memos that Comey had written himself that supposedly detailed conversations between Comey and President Trump. So Richman leaked these memos, or the contents of these memos, to the New York Times. And it turns out that Comey himself authorized Richman to do so, told him to do so. And we know all of that now. And so that's another theory of who the someone else is and who and what the conduct being referred to in charge 1 is. Now, as to the false or misleading statements in the obstruction charge, charge 2, nobody has any idea what those are. The indictment doesn't give a clue about it. Those false and misleading statements could conceivably just be another reference to the same false statement from charge 1, so it could be the exact same stuff, or it could be totally different. We don't know. Comey arguably made other false statements in that testimony. It was at that same 2020 hearing where Comey stated under oath that this infamous Steele dossier, I'm not going to go into it right now, but you can look it up and read about the Steele dossier if you want, that the infamous Steele dossier had not been used, had not been relied upon, had not been incorporated in, had not been used at all in an intelligence community assessment that was prepared by Comey and others, Clapper and Brennan, in 2017, right before Trump took office. And this intelligence community assessment was the assessment that Russia had interfered or tried to interfere in the 2016 election, and it suggested even the possibility of collusion between the Russians and the Trump administration, or the Trump campaign, and it's been talked about a lot. And Comey said in 2020 under oath that the infamous Steele dossier had not been used or incorporated or relied upon in that intelligence community assessment, and that's what most people believed for several years, that it hadn't been. But recent files released, disclosed by Tulsi Gabbard in the last couple months, they indicate and show that the Steele dossier was used and was attached to and referred to in that intelligence community assessment. And moreover, the Tulsi Gabbard documents suggest that it was Comey himself who insisted on putting it there. So that raises the possibility that Comey was testifying falsely or misleadingly about the Steele dossier and its role in that intelligence community assessment. And that could be the false and misleading statements, or one of the false and misleading statements referred to in charge 2. We just don't know, because the indictment doesn't say. Okay, now, is that kind of indictment constitutional, that kind of bare bones indictment? Well, I'll tell you what I would argue if I'm Comey's lawyer. I would say no, it's a constitutional problem. The lack of specificity in that indictment is itself a constitutional problem. Why? Because the 5th and 6th Amendments require that in any federal criminal case you got to have an indictment, and the indictment's got to adequately notify the defendant of the specific charges against them. Now, there are ways of fixing an indictment that isn't specific enough, but here, those ways of fixing it, they might not work, because if the statute of limitations is run, statute of limitations on these 2 crimes is 5 years, and arguably the statute of limitations is going to run on September 30th, just a few days from now, on both the charges. So the normal ways that might fix a deficient indictment, they may not work here, because basically they mean you got to file a new indictment, and you can't file a new indictment against Comey now because you're too late. Okay, so that's argument number 1 that I would make if I was Comey's lawyer. This indictment is deficient. There's another argument that I'm sure they're going to make, which is that charge 1, alleged false statement, where the indictment says, and it puts quotation marks around it, that Comey says he did not authorize someone else, the FBI, to provide anonymous service, an anonymous source to the news. Comey never used those words in the 2020 testimony. A transcript from that testimony actually indicates that those words were spoken, but they were spoken by Senator Ted Cruz in a question that he put to Comey. And Cruz himself, in that question, he was quoting language that had been used by a different senator, Senator Charles Grassley, at a different hearing back 2017. And he asks a question, so Cruz quotes Grassley, and he quotes Comey's answer to Grassley, and then he says, what about that, Mr. Comey? And Comey says in 2020 now, he says, I stand by my 2017 testimony. So that's the statement, I stand by my 2017 testimony, that the indictment's trying to turn into Comey making a false statement in 2020. because they can't just go after him for his 2017 testimony. The statute of limitations is already run. So the indictment's got to go after him for a 2020 statement, and that's a statement where he stands by his testimony. And I'm telling you, if I'm Comey's lawyers, I'm gonna, say, hey, this is just getting too complicated. And so my point here is, we don't know what the courts are going to say about that, but it adds an additional layer of factual and legal complexity to the case, and certainly to charge one. Now, I want to turn to some of the more important issues, because those aren't the deepest issues. Those are serious issues, but they're not the deepest issues about this indictment. The deeper issue is, of course, as you're probably reading about, you probably know that the indictment appears so blatantly to be the product of political pressure, specifically presidential pressure, brought to bear on the prosecutors down in the Eastern District of Virginia. So you got to consider some details. The Eastern District United States Attorney, she was just appointed a few days ago, less than a week ago. And she's the one who ran in on this rush basis. This is probably why the indictment is so bare bones. She rushed in on this without having a chance to prepare a better indictment, and she got that indictment from the grand jury. Now, what had happened was that the previous U.S. Attorney down the Eastern District of Virginia, his name was Siebert, he resigned. And reportedly, he was actually forced out. And reportedly, he was forced out precisely because he looked and looked at the Comey evidence, and he came to the conclusion that there was not enough evidence for him to bring a criminal case against Comey. And he apparently told the White House that, nope, there's not enough evidence there, I can't bring the case. And the president forced him out for that. And Siebert's a career prosecutor. He's a Republican, career prosecutor. So that doesn't look great from the point of view of asking whether it was political pressure, specifically presidential pressure, that brought this prosecution about. Now, does that kind of political pressure, does that give Comey a legal argument, constitutional argument? Can he say, pointing to that political pressure, hey, this whole prosecution is unconstitutional, throw it out? Yes, he can make that argument, but he very, very well may not succeed on it. Does not have high odds of succeeding on that argument. Let me tell you exactly why. The Constitution does not permit retaliatory prosecutions where where the government's retaliating against its political enemies. The Constitution does not permit a prosecution that's retaliatory against somebody's politics, somebody's protected First Amendment activity. It doesn't permit any of that. It's called selective prosecution, and it's unconstitutional. But showing that is very difficult. It's very hard to prove. You almost have to come up with comparable people who are out there who have committed almost the same crime in very similar circumstances and show that they had a different politics. They aren't the president's enemies, and he's not prosecuting, government's not prosecuting them. If you got that kind of comparable, then you got a case. Look, here's somebody else out there, he's done the same thing I did, but he's the president's friend, they're not prosecuting him, but they're coming after me because I'm the president's enemy. That's the kind of evidence that might get you across that line and allow you to prove selective unconstitutional prosecution. So if I'm Comey's lawyers, I'm gonna make that argument, but I would not say there's high odds of success on that argument, although it's possible. But, the deepest issues in this case are not even the legality of the indictment. We got to go even deeper, and I've got to express to you my opinion about these deeper issues. What's this deeper issue I'm talking about that goes beyond even the legality of the indictment? Well, here it is. There was a very famous justice of the Supreme Court of the United States, Justice Robert Jackson, not to be confused with Justice Ketanji Brown Jackson's earlier Justice Jackson. And before he was justice, he was Attorney General of the United States. And as Attorney General, he once gave a famous address, 1940, to a gathering of all the U.S. attorneys from all over the country. And in this address, let me quote to you some famous things that he said in this address. He said, the prosecutor has more control over life, liberty, and reputation than any other person in America. While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst, said then Attorney General, later Justice Robert Jackson. And it's because of that danger of abuse that the government should never prosecute a president's political enemies, not unless the case is open and shut, or very nearly open and shut. And given the paper-thin indictment in this case, and given the resignation of former U.S. Attorney Siebert on the grounds that there wasn't sufficient evidence, look, I don't know yet. I don't know all the evidence in the case. I got to wait and see the evidence, but it looks like that standard may well very not be met in this case. Now, I know what you're thinking, because I'm thinking it too. Trump supporters, they're going to rush in and point out that that standard was not met in the Biden era prosecutions of Trump himself or a whole lot of Trump allies prior to the election. They're going to say that the Trump prosecutions were in fact not only just as arbitrary and just as much motivated by political enmity, they're going to say they were a much greater abuse of prosecutorial power. Why? Because Trump was the leading candidate for president from one of the parties, and he's getting prosecuted by all these officers and members of the other party. So it's not just a political enemy. These are members of one party trying to destroy and derail the campaign of the leading presidential candidate for the other party. Trump's supporters are going to say that, and guess what? They'll be right. They'll be right on both counts. The Trump prosecutions were just as politically motivated as this prosecution of Comey arguably is, and they were much greater abuses of authority and much greater threats to democracy. So I know all that, and that's all true. Even though a lot of folks aren't acknowledging this, and it just drives me crazy. Now, I told you before, the New York Times is saying this is a break glass moment. Here's what the New York Times is saying, that this Comey indictment has thrust the Justice Department into perilous new territory, risking unprecedented arbitrary prosecutions against the president's political enemies. All of which conveniently forgets that this new territory is not new territory, it is old territory. And it conveniently forgets that the Times never criticized the equally arbitrary prosecutions against Trump and his political allies. Not only did the Times not criticize that, on the contrary, the Times, along with lots of legacy media, they just trumpeted over and over that Trump was a convicted felon, and they ran with that line throughout the 2024 election campaign, never mentioning that convicted felon status, that the crime that Trump was purportedly convicted of was a crime almost nobody could understand. Lawyers could not understand it. It was the state of New York had taken this statute and twisted it around and prosecuted Trump under a theory that had never been used before. And it was so complicated, almost nobody could even understand what it was that he was found guilty of. And by the way, the indictment in that case was just as deficient. And the political targeting was, just as obvious, if not more so. So look, the Comey indictment is not an unprecedented break glass moment. But that doesn't mean it's not serious and dangerous, and we got to think very seriously about it. What the Comey indictment is it's a continuation of a cycle that began before the 2024 election, in which the party in power comes after and prosecutes its political opponents. And once that kind of cycle starts, it is very hard to stop. And it is a potential constitutional death spiral that could tear this country apart and turn it into a third world banana republic, in which countries there. It's what they're always doing. As soon as somebody new comes into power, they prosecute the former president. We can't become a nation like that. And this is a very serious thing to worry about. Now, I know it's almost outrageous to expect Trump to forbear given what he went through. It seems unreasonable, almost outrageous to expect him to lay off, to forbear, given what they did to him. But that cycle I'm talking about, that's a formula for a constitutional disaster. So here's my bottom line. Here's straight down the middle's bottom line. Unless those charges against Comey really are airtight, they should not go forward. Well, that's my opinion, and that's all from me for now. Stay tuned for the next Straight Down the Middle.